Hello everyone, and welcome to our lecture recording for chapter 15. Now, in the last lecture recording, the one for chapter 14, I told you that we will be jumping from chapter 14 to chapter 19, and that's incorrect. So we are responsible for chapters 15 and 16, but we are not responsible for chapters 17 and 18. So once we finish chapter 16, we will jump directly to chapter 19. So the ones that you are not responsible for are chapter 17 and 18, but you are responsible for 15 and 16. Alright, so let's get started with our lecture for today. And this is a continuation of our discussion of contracts, the substantive area of contracts, and we're gonna talk today about how we bring a contract to an end. So we're talking about simple contracts. You remember we said we have to start with the analytical structure on the existence of contracts and then move on to look at the validity of contracts. Now we said in our first analytical structure we have to look at three sub-elements. Basically we need to look at whether there's an agreement and whether there was intention to create legally binding relationships and whether there was a valuable consideration. And then we moved on to the validity analytical structure, and we said again there are four sub-elements, and we looked at things like the capacity to contract and the consent, genuine consent to contract, and legality, and the question of form. As we said, some contracts would require certain types of forms. For example, some of them would have to be in writing and so on. Now today we're going to move a little bit to the end of this analytical structure, and we're going to talk about basically how we end contracts. As always, we start with the chapter learning objectives, which are on page 385, and we are going to discuss the first two simultaneously. So we're going to look at the doctrine of privity of contract and also describe the circumstances in which what we call novation and assignment of rights and liabilities can change contractual obligations. So the starting point is on page 386, and you find that there is a discussion of what this chapter does. So it says in the purple box on page 386, this chapter considers firstly how third parties can acquire rights and incur liabilities under a contract, secondly the circumstances in which the obligation of the parties to a contract can be discharged or resolved, and finally the main remedies that are available for breach. And you'll find that there is an in brief box that explains what we mean by privity and assignment. So it says, as a general rule, only the persons who are parties to the contract can acquire rights and incur liabilities under it. So think, for example, of our pen and $10. So I will sell you this pen for $10. We exchange these promises, and that creates rights and obligations between us in relation to the pen and the money to be paid. Okay, but these rights and obligations, this bundle of rights and obligations, is exclusive to me and you because it's our contract. See, it's not like the rights, for example, and obligations that would arise under torts, where you would have a general duty of care on the public, or in certain relationships, for example, between a manufacturer and a consumer, or between employer and employee, where these rights and obligations would arise by the operation of the law because of this legal theory we call torts. In contracts, we devise what we want to adhere to as rights and obligations, but these rights and obligations are limited to us. So again, privity here means that these rights and obligations are acquired only by the parties to the contract. So the position of third parties is that obligations under a contract will generally not be transferred, or cannot generally be transferred, unless all the parties consent. If that happens, then we have something called novation. Okay, and there is something in equity, and in limited cases the law, equity, and in limited cases the law, so we're talking about at common law or statute, permits an assignment, transfer of rights. Okay, so transfer of rights. Okay, let's just unpack this for a bit more, and let's look at this slide that we see in front of us. Okay, now the starting point again is this doctrine of privity of contract, and as you can see it's linked at the bottom of the slide with something called the doctrine of legitimate expectations. And this legitimate expectations doctrine is discussed, if only briefly, but it's discussed in this case called Trident on page 387, Trident General Insurance Company Limited and McNeice Brothers Proprietary Limited. Now if you jump to the decision on the right hand side in the box discussing this case, it says under the decision, the privity doctrine was in conflict. The privity doctrine was in conflict with legitimate expectations, i.e. with the doctrine of legitimate expectations and the expressed intentions of all the parties to the insurance contract. Okay, so sometimes you'll find that there are there's tension between this doctrine of privity of contract and other doctrines like legitimate expectations, and that would give rise to certain exceptions. Okay, to certain exceptions to the doctrine of privity of contract. Okay, so you'll find at the bottom, or let's start with acquiring rights, because we're going to discuss all of these together. It says there, as a general rule, again page 387, says as a general rule only the persons who are parties to the contract can acquire rights and incur liabilities under it. Again, this is what we mean by privity of contract. Drop to the bottom, or let's read the second paragraph. Says until the High Court Australia decision in Trident, a third party would not have been able to acquire any rights or incur any liabilities under the contract. Why? Because the third party was not a party to the contract. So again, in very strict application of the doctrine of privity of contract. However, while the third party, let's call them C, may not be able to sue A on A's promise to B, that's the contract. So I for example promise to sell you the pen, that's I'm A, you're B, my promise to you, and of course your reciprocal promise to pay me $10 for it. So C may not be able to sue A on A's promise to B. B may be able to sue A for breach of contract. Okay. Now there are still, however, exceptions to this doctrine of privity of contract, and they come from different sources. So at common law you'll find something called novation. There's a longer list. You'll find again starting on page 387 at the bottom. It says there are a number of general law and statutory principles that can enable a third party to overcome the doctrine of privity. So you can actually sue A on A's promises to B. Okay, they are a means used by the courts to get around the problems associated with the doctrine of privity by applying these other legal principles to the facts of the given case. So at common law you'll find that we have things like agency in relation to an undisclosed principle. We'll talk about that in more detail when we discuss chapter 19. Then we have novation. So this is here what we say, that there are two elements for novation. We'll find a longer discussion of novation on page 389, but novation basically requires two elements. First, discharge of the existing contract by agreement. Okay, so we'll rescind the contract and then entering into a new contract. So that's what we said earlier when we looked at the in brief box. This is what we can do. So cannot be transferred unless all the parties consent. So this is transfer of rights and obligations, or rather transfer of rights by consent. Okay, and you see the other exceptions listed on this slide, like trusts, leases, restrictive covenants, estoppel, and unjust enrichment. Okay, now we're going to focus on some of these, not all of them. So we're going to look at novation in some detail, but there's also statutory exceptions, and you see that they are mostly linked to the ACL, the Australian Consumer Law, but there are also things in relation to negotiable instruments, which you can look at in more detail in chapter 32, which is online. We're not going to discuss it or cover it in any detail, but if you're interested in negotiable instruments and how that links to this idea of exceptions to the doctrine of privative contract, you can go there and have a look at. So you have negotiable instruments as long as there has been a valid negotiation to the new parties. So there are exceptions that come from those statutes, the Bills of Exchange Act of 1909 and the Checks Act of 1986, and the reference sections on page 388. You can look at that. There are also other exceptions like under property contracts, but the one we want to focus on really is under consumer law. So the absence of privity between the parties will not prevent a claim under the Australian consumer law for things like misleading or deceptive conduct under section 18, or for false or misleading representations under sections 29 to 37 of part 3-1 division 1, or unconscionability under sections 20 to 21, or for that matter actions against manufacturers and importers under parts 3-5. So the idea that there, even though that the consumer has a contract with the retailer, not the manufacturer, that's not going to stop this consumer from bringing a cause of action, suing the manufacturer for something in relation, for example, to unconscionability or actions again in general against manufacturers and importers. Now there's also an equity exception, and that's on page 389, and you'll find that equity now is really exceptions in relation to assignment of rights. Okay, you can also look at that under leases on page 770, but for our purposes now, for this recording, we're just talking about obligations and rights. So you'll find that on the left hand side of this slide, at common law, you'll find that there could be exceptions in relation to obligations. So the assignment of liabilities, again there it says on page 189 at the top, as a general rule, a party who has contracted to perform obligations, so you have liabilities there, for example, pay me the $10, that would be your liability, under a contract cannot transfer those obligations to another. Okay, the promisee, so I would be the promisee if you are going to pay me the $10 so that I can give you my pen. That would be your promise. You are the promisor, I'm the promisee. So me, the promisee, cannot be forced to accept performance or a promise of performance from any person other than the promisor, unless the liability that's transferred is one that involves no particular skill and is not connected with the character or credit or any other personal quality of the promisor. Okay. Then there is a discussion about novation. You can have a look at that on page 389. Again, this is all in relation to assignment of liabilities, you see. So again, novation, it says if all of the parties consent, again this is the idea that we talked about in the brief box, liability may be transferred by way of novation. This is only liability here, okay? This is a tripartite, so this means that there are three parties to this agreement, where the original parties agree to rescind, so basically cancel their contract in consideration of a new contract being entered into on the same terms between one of the original parties and a third party. Okay, so this involves substituting one original party with the third party in what is a new agreement, and there's an example given to you. If a partner in a partnership dies, the old partnership is dissolved and replaced by a new one. And if the creditors of the old partnership continue to deal with the new partnership, they are considered to have accepted the new partner as their debtor. Okay, so they are transferring basically the liability that was on the partner who died to this new partner through this idea or this legal theory of novation. Okay. On the right hand side of the slide, you find that if we want to assign rights, so you want to give rights to someone other than someone who is party to the contract, so these could be transferred to third parties. An assignment can be by statute or operation of law under the ACL. So you see that common law assignment of rights is not possible. That's why we look at it under equity. Equity permits the assignment of contractual rights, including debts, provided, there's a proviso, provided that the following matters are complied with. And you can have a look at these matters on pages 389 and 390. 90, and then a continuation of what was required under statutes. So property law statutes of the states and territories allow rights to be assigned, and for the assignee to sue in their own rights or in their own name, as long as a few as well requirements are satisfied. And the same thing with operation of law. In certain cases, assignment of rights can take place by operation of law, and they give you the examples of the executor of a will or the estate of the bankrupt, okay, or under consumer law. And the one we want to focus on really is consumer law. So a contract requiring the performance of personal service is not assigned because it's personal service. So for example, a particular artist painting a portrait, you can't assign the rights under those contracts the way we talked about in relation to the other types of contracts in equity. All right. Let's then move on to the third objective for today, which asks us to list methods of discharge of a contract. Now this basically means ending the contract, bringing the contract to an end. Okay, so the most obvious thing is that you do it. You discharge the contract by total performance. That's the most reasonable thing that comes to mind. What they call the abductive logic behind it. So if I promise to sell you my pen and you promise to pay me $10 for that pen, so once we execute these promises, so I give you the pen and you give me $10, we have total performance, and that brings the contract to an end, and we say that the contract has been discharged. So I discharge my obligation to give you the pen, you discharge your obligation to pay me the $10, and the contract comes to an end. You'll find that there's an in-brief box on page 291 that gives you more sort of a summary of how these methods of discharging contract can come about. So the first one is performance. So the parties to the contract carry out exactly the terms, i.e. the promises of the contract, as we said, selling my pen for $10. In limited cases, substantial performance, so this is different than total performance, acceptance of part performance, and obstruction, okay, by the party may discharge the contract. So sometimes if you're trying to actually give someone $10, or I want to give you my pen for that $10, but I can't find you. You're not, you're not returning my calls. You're not answering my emails. So I can't really reach you, and I can't give you the pen, and that would eventually mean that we have obstruction. Okay, but there will be other things that would result. So we'll talk about it in just a minute. But there are other ways of doing this. Bringing the contract to an end or discharging the contract could be by agreement. So we both agree that we will just forget about this contract of selling you my pen for $10. So as the contract was created by agreement, so it can be changed by agreement. You see, this could be by a mutual discharge, so we both agree to it, or a release or waiver, and you'll find that there are more discussion of these terms to come, by one of the parties. A substituted agreement could also be one of the ways to bring the contract to an end through agreement, a substitute agreement, or something called accord and satisfaction. Then there could be also something called the doctrine of frustration. So the contract could be discharged as a result of impossibility of performance, okay, due to an event unforeseen by either party, such as destruction of the subject matter. So my pen, the one I want to sell to you, got stolen, got broken, something happened that we didn't foresee could happen, and that means that we cannot actually conclude this transaction, and that brings the contract to an end. It's discharged through this doctrine of frustration. Okay, there could also be frustration through changes in the law, or non-occurrence of a basic event, or physical impossibility under a contract of personal service, or a radical change in state of affairs. There could also be operation of law. So the contract may be discharged independently of the wishes of the parties by operation of law, for example, bankruptcy, or marital, or rather material alteration, or mergers, or death of either party to the contract, or expiry of time. And there's also lapse of time, where no time has been specified, a reasonable time has lapsed, and that means, or elapsed, and that means that the contract comes to an end or is discharged. Okay, so I don't have to carry out my obligations, and you don't have to carry your obligations, because a reasonable time has passed and I didn't sell you the pen and you didn't pay me the money. Okay. or by virtue of a term in the contract itself, or by breach, so by one party failing to perform their obligations as agreed. That's what we mean by breach. Okay. I'll leave it for you to actually go through this construct, or these different ways of discharging the contract on your own. I think that's reasonable. I'll leave that for you to go through. I just want to draw your attention to something called divisibility of contract, because it brings also a different concept called quantum meruit. So let's then talk about performance in such for just a minute. So as you can see, there's something called quantum meruit, as you can see here on this slide on the left hand side on the top next to total performance. So this part here called quantum meruit, and this is something I just want to make sure that you are familiar with and know what it actually means. And the discussion on this you'll find, in fact, given to you on page 393. So let's just start from the top. So we're saying that there could be total for performance. There could be, first of all, discharge by performance. So when the promises made by the parties under an agreement have been properly performed by the parties, then the contract is said to be concluded by performance. Straightforward. However, there are two types of performance. There's actual performance and attempted performance. Okay? And under actual performance, you will see that there's either variation from the terms of the contract. So it says the parties are discharged from any obligations, provided that their performance of the contract corresponds as closely as practicable. Okay, so it's not total, but as closely as practicable with the terms of the contract. Now this is of course the strict rule of complete and precise performance, but there are also exceptions. Okay, so there's partial performance, for example, at the bottom of page 392. It says there are a number of exceptions to the rule of precise performance. When there has been partial performance, payment doesn't automatically follow unless the contract is a divisible contract, there has been free and willing acceptance of partial performance, substantial performance has taken place, or the actions by the non-performing party prevent performance. And that's where we want to come and talk a little bit about what is a divisible contract. So you'll find examples on page 393. There's an example of a divisible or divisible contract, which is in relation to a contract with a builder. Okay, so this is the top of the page, and then in the middle of the page you'll find another example of an entire contract. Okay, so the idea is that it's not always easy to tell whether a contract is entire or divisible. It is a question of construction, taking into account what the parties said and did at the time of contracting. And they give the example: in a contract with a builder to build a house, the contract will often state that the builder is to be paid by stages, so there are milestones, and that the first payment is due and payable when the site is cleared and prepared for the slab, and the last payment is due and payable at lock up, and various stages identified in between. So this is an example of a contract that is divisible. So why is that important? It says if the builder was unable to finish the contract to the very end, to the lockup, it would not mean a loss of all rights for the builder, because it would be possible to identify rather what stage has been reached and therefore what payment was due. So it would then be possible for the builder to seek payment for what has been completed. On this basis, equitable basis, we call quantum meruit. So what he deserves, basically what he has accomplished or what he has done. For this is based on an implied promise, so implied promise to pay a reasonable sum for work actually done, or restitution. Now we'll look at this in some more detail when we get to chapter 16, our next lecture recording. But remember that this is based on an implied promise. Okay. Now let's look at the second example of this entire contract. So with the house, now it says at lockup stage, imagine that you have entered in a contract with a painter. So you have finished the lockup stage, but now you want to have another contract with a painter that states that payments for painting the house is to be between quotation marks payable on completion. So you're not going to pay them by stages, really. You're just going to pay them at the end of the work, at the end of everything. Okay, and this situation says failure to complete the painting could have serious consequences for the painter. Why? Unlike the case of the builder where the contract could be said to be divisible, the contract here appears to be entire. Okay, and entitlement to payment only comes upon completion of the task. The reason is that the consideration for the right to demand payment is the implied promise again to complete the work. Here it's the implied promise to complete the work, not the implied promise to pay a reasonable sum for work actually done. Okay, and in this type of situation, the entire contract situation where there is an express contract still enforced to pay the full amount, so there's express promise to pay the full amount, the painter rather, cannot recover any money even on the basis of quantum meruit. That's the most important thing, because the express promise of this contract takes precedence over the implied promise. Okay, so express promises take precedence over implied promises, which means that you cannot rely on quantum meruit to go and argue that you should be paid for work done because you haven't completed the whole thing, because it's an entire contract. Okay, so the important thing for us here is to understand that this quantum meruit is really something that is linked to divisibility. So look at page 394 at the bottom there, it says quantum meruit. This is usually confined to those cases in which a person renders some service at the request of another and no remuneration rather is fixed. So the party providing the service bases their claim on an implied term that they should be paid a reasonable amount for the work already done. But you remember, of course, that there could also be express terms that trump this implied term. Okay, I'll leave the rest of it for you to look at. There's a business tip on page 395. Says take care where there is a payment by check. So if the creditor has expressly asked for payment by check, the contract is discharged as paid. If the check is then dishonored, the creditor can sue only the debtor or drawer of the check. The creditor cannot sue on the contract since this has been discharged in the manner requested by the creditor, that is by check. If the creditor didn't ask for payment by check, then the creditor can sue on either the check or the contract. Also look at the risk management alert. It says the most secure method of payment as far as a creditor is concerned is by bank check. You can follow through that. There's also discussion of payments by post. Okay, so it says on page 396, the risk management alert to determine at whose request payment by post was made, because it is then possible to ascertain whether the post office was the agent of the creditor or the debtor. Okay, and that's the two types of possibilities that are given to you again on page 396. Where the request is by the creditor, the post is the agent of the creditor. But if the debtor pays by post, so that would then be the post office is really the agent of the debtor. Okay, all right. So we said that there are other things that could happen by agreement. So the starting point of that would be on page 396. So this is discharge or ending the contract by agreement, which could be either mutual discharge, release, or a waiver. It could be condition precedent or condition subsequent. It could be substituted agreement or a cause of satisfaction. So under mutual discharge, parties agree to abandon their original agreement while still executory. So I want to sell you my pen, you want to pay me $10. This is all about executing these promises in the future. We haven't done anything yet, but we agree that we discharge the contract, so I don't have to give you my pen, you don't have to give me the $10, and we haven't done anything yet. That's executory, that's mutual discharge. It could be by release. So the party who performed their obligations releases the other party before they have performed their contractual obligations. So I might just give you the pen, for example, and then release you from your obligation to pay me the $10, and that means that we have a completed or discharged contract, and that's the end of the matter. Or it could be by waiver. So only one party does not insist on strict performance while the original agreement is still executory. So you might tell me, look, I wanted to buy that pen, you know, the one that's sort of you know, red pen, but I'm happy with any color that you have. It doesn't have to be that color. See, that kind of thing. So this is a waiver. We haven't done anything yet, but one of the parties does not insist on strict performance while the original agreement is still executory. We haven't still executed the agreement. or our promises. There could be substituted agreement, as we said, so a new agreement is substituted for the old by the parties, for example, through novation, or there could be accord and satisfaction. So the party who performed their obligations agrees to relieve the other party in return for doing something. So I don't want you to give me a red pen, it's okay, it could be of any other color, but I want you to give me something in return. For example, maybe you can give me a case for the pen or something. The new agreement is the accord, and the satisfaction is the consideration for the accord. So the consideration is what we call satisfaction. So the satisfaction in that case would be, for example, I'm happy with any color instead of the red color that we originally agreed on, but in return of that change, if you like, I want you to give me a case for this pen. So that would be the consideration with which I would buy your promise to accept a different color. There's also condition precedent and condition subsequent. I believe we have looked at that before. So a condition precedent is simply a precondition that stops a contract from coming into existence, and a condition subsequent is a term that, if not complied with, brings the contract to an end. Alright. We would like to look at frustration in some more detail. So the doctrine of frustration starts on page 399. Alright, so let's just talk a bit more about this doctrine of frustration. So it starts on page 399, and it basically makes the contract void. So it can be enforced, okay? And it would be void for frustration from the time of the frustrating event, okay? Like, for example, an earthquake that prevents us from continuing with a building project. So from that point on, from the time that the earthquake happens, that makes the contract between us up from that point forward void, okay? So frustration terminates rights and obligations as to the future, but accrued rights and obligations are enforceable. So anything accrued or anything that accumulated until the point of this unforeseeable event like an earthquake happens, anything up to that point is still accrued and is enforceable, rights and obligations. So can recover based on quantum meruit, based on the work done up to that point, okay, as if it's a divisible contract. And you could look at these two cases of Codelpha and Fibrosa. So they will give you an idea of how this doctrine works, and as I said, these will be discussed in more detail in the colloquy on the doctorials, the cases that are listed here. So money paid as a deposit, for example, could be recovered if there was a total failure of consideration. We looked at this point as well in the past, when there is a total failure of consideration, if you remember, when we looked at the total capacity and the issue of minors. Note that frustration is a question of law for judges to decide, and there are also exceptions to this doctrine of absolute liability. So it's an exception really to the doctrine of absolute liability, and it has these four elements. There has to be an unforeseen event, neither party caused that event, and no provision for the event was given in the contract, and it would be unjust to hold the parties to the contract given the occurrence of this event. There could be frustration through different means or methods or ways, for example, physical impossibility or change in the law, or non-occurrence of an event, or the state of affairs ceases to exist. You can have a look at these different law cases, and how they explain these different ways of bringing about frustration. All right. Let's then look at the last objective for today, and that would be our objective to explain the situations in which a contract may be breached. Alright. Before we get there, let's just look at a bit more at these two different terminologies, one of them called termination and the other called rescission. What's the difference between termination and rescission? Okay. So look, termination of contract at common law means that this is basically a remedy for breach of contract, because we're going to talk about breach. Okay. restitution of contract in equity is just retrospective avoidance of a contract. You're going to avoid the contract retrospectively. Okay, so available unless there was affirmation, delay, impossibility of restitution, or effect on third parties. Okay, and it applies where the contract is voidable, e.g. for misrepresentation or mistake. Rights and obligations will remain until the innocent party rescind the contract. So this is what we mean by rescission. Okay, and restores rather the parties to their position prior to the contract. That's what we mean by rescission and what occurs if rescission takes place. Okay. Termination of a contract, however, which could also happen, you can terminate pursuant to a term of the contract. So there's something in the contract like a clause or a term that says you can terminate this contract if so and so and so. You could terminate the contract based on that term. But this is generally a breach of contract remedy. So this is a remedy for breach of contract. Okay. So rescission is a remedy when you have an avoidable situation. So an avoidable contract. Avoidable contract. So a situation like misrepresentation or mistake. Then you can elect to rescind the contract because the contract is avoidable. But here the contract has already been breached. So I want to sell you a pen, and you want to pay me $10 for that pen. That's our contract. Now I decided not to sell the pen. So I said I'm not going to sell you the pen. That would mean I breached the contract because now I will not be following through with my promise to give you the pen for that $10 you were going to be paying me. So that would be a breach of the contract. Now that I have breached the contract, you have the right to terminate the contract. So it's a breach on my part and a termination on your part, meaning that you don't have to, you would consider that the contract has come to an end. It has been discharged, meaning that you don't have to pay me the $10, and meaning that there would be nothing else I could come back and tell you about in the future to say, for example, oh, now I've changed my mind, I want you to buy this pen from me now. We can't do that anymore because we have terminated the contract. So the obligations of the parties to further performance is discharged, and any accrued rights prior to termination will still remain. So similar to what we saw in frustration. Innocent party also has right to damages, and both parties have right to restitution or restoration. If you want to know more about that, go to page 414 of your textbook, and you'll also find specific performance would not be available after termination. So if I terminate the contract, I can then go back and sue you and say, no, I still want that pen for this $10. That's what we mean by specific performance. I want to compel you, I want to force you to give me the pen, even though you don't want to give it to me. So I'll take it to court and ask the court to tell you to give me the pen for that $10 I want to pay you for it. So that's not what I mean. But if I terminate the contract, then I cannot go and do that. I cannot go and sue you for specific performance. Alright, so this is the last thing I want to look at. It's discharge of obligations because of a breach of a term. So if one of the parties breaches a term in the contract is terminated. Breach of a contract, so the contract is terminated, there could be actual breach or anticipatory breach. So actual breach means that there was failure to comply with the term of the contract. Okay, it could be a failure to comply with a condition. You remember the difference between conditions and warranties under business-to-business contracts. So this would be a total breach if there was a failure to comply with a condition, or a partial breach where it was a failure to comply with a warranty. Okay, but in each of these instances, you'd still have an actual breach, or you could have anticipatory breach. So you could either announce that you're no longer interested in carrying out obligations, so I'm not interested in giving you the pen, or you delay in performing the obligations where time is of the essence. Okay, either of these will give you anticipatory breach, and these actions amount to what's known as anticipatory repudiation. Anticipatory repudiation. Alright, and that then brings us to the end of this lecture. I just want to say one more thing about the effect of breach and the business stuff on page 407. just before we end this recording. So it says, beware of the effects of anticipatory breach. Allowing the innocent party to anticipate a breach, okay, has the benefit of allowing them to mitigate or minimize their loss by making alternative arrangements. So if I tell you in advance that I will not actually be able to carry my part of this bargain, the promises under the contract, that would give you time to go and find something else. For example, find a different pen, right, which reduces the damages that the guilty party may have to pay for breach. So by electing to wait until performance is due, there's a risk. The risk is that the party in breach may have an excuse for not performing. For example, because of a supervening event frustrates the contract, thereby depriving the innocent party of remedy. So the key point is that if you find that someone gives you the heads up that they are not going to be able to perform their bargain, the part of the contract, then you need to find alternatives, just like we talked about in negligence, for example, where you have to mitigate your losses. You see, the same thing here. If you can see that the other party is not going to actually follow through with their promises, you need to find alternative arrangements. And the last point on page 108 talks about the effect of breach. So if one party fails to perform their obligations under the contract, there's a total breach or breach a condition, okay, then you, the innocent party, is entitled to treat the contract as ended, so terminated, from the time of the terminating event. So that's what we mean by the terminating event, the total breach or breach of a condition, and may be able to recover damages. The contract is not treated as void ab initio, so not from the beginning. Any rights and obligations that have already arisen, that accrued from the partial performance of the contract, would remain unaffected. The parties are relieved only of the obligation to perform after the date on which the contract was discharged. Note that if the party breaches a less important term or warranty, then there is a partial breach, and while the innocent party is still going to have to carry out their obligations in the contract, they may sue for damages. Here there is no possibility of rescinding the contract. If the party indicates that they will not be performing their part of the contract prior to the time for performance, the innocent party can immediately take the contract at an end and sue for breach. There is no need to wait until actual breach occurs. That's the point that we said previously under the business tip. And in the case of consumer contracts, of course, it's important to note that the Australian consumer law has replaced the implied conditions and warranties found in these contracts with consumer guarantees. We said this previously. However, where a party is in breach, it is to be determined whether the problem with the goods is minor or major. So if it's minor, in which case the supplier can choose between providing a repair or offering the consumer a replacement or refund. But if it's a major failure, in which case the consumer can reject the goods or services and either choose a refund or replacement or ask for compensation for any drop in value of the goods or services. Remedies for breach of contract are considered in the next chapter, and that's going to be the topic of our next lecture recording when we look at chapter 16 and the remedies in contract. And that then brings us to the end of our lecture recording for today, and we will leave it there and talk to you again